Kia ora koutou katoa. So warm greetings to everybody and welcome to the Victoria University Law School. So I'm Nessa Lynch, an academic here at the Law School and chair of our lecture today. So we're delighted to have you with us. We've got a small group in the room and a very large group online. And we're here for part of the New Zealand Centre for Public Law Office Holders lecture series. So we're delighted to be able to welcome the Children's Commissioner, Judge Andrew Becroft. And this is part of a series of talks, interconnected talks that he's doing over the next while, reflecting on his term as Commissioner and the challenges for children and young people in New Zealand. So we've got a focus today on youth justice, which is a subject which is very close to the Commissioner's heart and also to my own. So I'm going to formally introduce the Commissioner to you very shortly, but I just want to welcome those who are here with us in the room and also virtually. So obviously this terrible virus has affected many of our plans, and one of the things that affected was having a fully in-person lecture here today. But I think in the scheme of things, that's fairly minor. And actually, it gives many more people the opportunity to access the lecture. So we've got a couple of hundred people registered for the online, and I know many more will be catching up with the recording. So it also allows that accessibility and participation. And so I want to acknowledge Kate and Chris for their help in setting this all up, and Calvin, and because there's a lot of work that goes along behind the scenes. And so with us in the room, we've got, which is allowed under the Level 2 rules, we've got some of the Office of the Children's Commissioner's staff, a small number, and we've got some students from the Victoria University Law School. So it's really appropriate that we have some of our students here today, because Judge Becroft has always been very generous with his time in giving guest lectures to youth justice, and I know that's inspired many of our students towards careers in youth justice. So we have a precious hour together. So I'm going to introduce the Commissioner in a minute. His achievements are many, but we'll just highlight a few things. He's going to speak then for approximately 30 to 35 minutes on his topic of 5 missing pieces in the youth justice jigsaw. I will make some brief remarks in response. So introducing some work that has been ongoing on with the Commissioner and his staff, Professor Ian Lammy and Tamara Wilson, law student here, around legislative reform to the youth justice system. So we'll hopefully then have a little bit of time for questions as well. So people who are online will be able to see any questions that you put through in the chat. So please put through anything and we'll try and get around to some of them. All right, so I will now introduce the Commissioner. So His Honour Judge Andrew Becroft was appointed a District Court Judge in 1996, and in 2001 he became the Principal Youth Court Judge for New Zealand, a role that he held until 2016 when he was appointed Children's Commissioner. So he did go to the wrong law school, but we've forgiven that. So particularly as one of his very talented children studied law with us here. So he spent time in private practice. He worked on establishing the Maori Community Law Centre and then worked as a barrister in South Auckland. He started on the District Court bench in Whanganui in 1996. He's held a range of governance roles in the legal profession and the community and has been honoured with a number of awards, most recently the Public Service category at the Wellingtonian of the Year Award. So the judge has a very long list of achievements and is well known around Aotearoa and the world for his work. But I'd also just like to acknowledge, some of the kindnesses that he's shown myself and our students. I'd like to acknowledge that he's been tireless, fearless, and enthusiastic in his advocacy. And I think many of us have been in receipt of weekend and late night emails gathering support for various important issues. He's sometimes angry about the injustice that is present when that's necessary. And I'd also like to acknowledge he's always open to new ideas and to challenges. And I've certainly done some of that challenging. And he's open to new ideas and being challenged on his views. So we're really going to miss him when he finishes his term. But I know whatever role you'll have, you'll be having that same tirelessness in your advocacy for children and young people. All right, so I'm going to hand you over to the Commissioner.
Inga mana, inga reo, inga rangatira, inga kuia, inga hoe wha, tēnā koutou, mihi mai karanga mai. He pai ki te kōrero ki e koutou I tēnei rā, tēnā koutou katoa. Being Children's Commissioner has been one of the genuine privileges of my life. And as I reflect, it's never been more important that we have a vision for New Zealand's children, by which I mean our under 18-year-olds. I think the book of Proverbs was right when it said, when there is no vision, people perish. Communities stall, they paralyse, decay, wither on the vine. We've wrestled a lot in our office about what is a vision that would be appropriate for all New Zealand children, a New Zealand authentic vision. I wouldn't be Andrew Becroft if I didn't start with a t-shirt, and I've got one. I think this vision from this famous New Zealander is just terrific. You probably know Dame Fina Cooper. Take care of our children. Take care of what they hear. Take care of what they see. Take care of what they feel. What a great threefold challenge. For how the children grow, so will be the shape of Aotearoa New Zealand. If we are involved with children, if we are day to day doing our level best, make no mistake, we are involved in nation building. Youth justice included. Youth justice done well is about building Aotearoa New Zealand. Always remember Martin Luther King saying, we may not be able to do the great things, but we can do small things in a great way. Day by day, that's the challenge for youth justice. So let me set the scene and ask a question. I'll get some feedback. Looking at all of New Zealand's under 18-year-olds, how many are there? Any guesses, quickly? It's all under 18-year-olds, 0 to 17 included. It's going to be more than 1,000, more than thousands. Any guesses? Do I hear?
80,000?
80,000?
A million.
A million. I've got a million on the table. More or less than a million? This is the answer. 1.156 million. How are we doing with that huge group, a quarter of our population? How are we doing? When I answer that question and think about it, I'm reminded of an experience in the Manukau Youth Court. And a young fellow walked in wearing a t-shirt. So another t-shirt for you. And he just stood with the t-shirt looking at me. Now, I think when I looked at it, as you will think, he might have had some reservations about the judge that was presiding and might have perhaps wanted it to be someone different. This is what his t-shirt said. I mean, it was a pretty clear challenge that I received. And I said to him, we want to encourage participation with young people. I said, that's an interesting t-shirt. He said, oh, good boss. I said, well, we're getting way ahead of ourselves, aren't we? I mean, calling yourself a criminal, you haven't even answered the charge. We don't even know where you are. Slow down. His lawyer was on his feet at this stage, clearly wanted me to shut up. But I boxed on and said, well, I can't fault your theology. So I'm sorry. You won't know what I mean by theology project. He said, I do. Sort of God stuff, isn't it? I said, yes, and you know, you have no argument with me. As a Christian myself, on the other side of heaven, I'm sure there will be perfect youth justice. I believe in that. But this side of heaven, it's not so perfect. And in fact, today in the Manukau Youth Court, you're stuck with me, Judge Becroft. And he just looked at me without it all being rude. He just said to himself audibly, well, I hope you get it right. I mean, that's the challenge for all of us in youth justice. I remember those words. Are we getting it right? Are we getting it right for our children and young people? And when I'm asked how well are that 1.2 million or so New Zealand children doing, there's one really easy introductory summary point. 70% do well, they thrive, and some do exceptionally well. 20%, however, face some significant disadvantage and are in environments that really cause them to struggle. And 10% That's at least 125,000 New Zealand children are in chronic, intergenerational, long-term, deep material disadvantage. A constellation of different issues. Now, that doesn't mean there's some form of inevitable bad life outcomes for them, but it means they're at very high risk of having some pretty tough life outcomes. And that 70-20-10 applied across the board. It's not exactly right, but those three groups emerge when you look at all of the stats. Not only is that 70-20-10 big for New Zealand, it's big for youth justice. And of course, I'm talking today about what we can do for the youth justice system. That's 14, 15, 16-year-olds, 17-year-olds. How we could fix some ingrained issues. But actually, fixing that would actually be the best thing we could do. And I'd like to suggest today there are three things behind that 70-20-10, particularly that 10. And these are issues for the youth justice system every day. The first is child poverty and material disadvantage as a risk factor. Is what's called a social gradient in New Zealand. The poorer the family the child comes from, the greater the risk of all the bad life outcomes we talk about. We need to work so hard for that group. That's the group that's at the serious end of the youth justice system. Inadequate early interventions. We talk about the vital importance now of the first 1,000 days. When I sat in the youth court, time and time again, I thought the real issues are way upstream in a young person's life. That's where the real challenges were laid down. That's when the issues developed. First 1,000 days, we know even before birth now. We know fetal alcohol spectrum disorder is an enormous issue. We know that maternal mental health is a huge predictor of good life outcomes. What are we doing to wrap community services around mothers who are expecting children? It's a fantastic thing we could do. And we have a child offender system. I'm not talking about that today. That's before the youth court. That's 10, 11, 12, 13-year-olds. You know, just about 99.9% of those children are known to the care and protection system and to health and to education. That's the group that almost always graduates into the youth justice system and often the adult system. So, I mean, the real questions today, the real fix is way earlier. I want to make that point so clearly. And the last thing to talk about is the lethal cocktail of colonisation, the C word that some people find really hard to accept with modern day systemic bias, racism. Those twin issues have an enormous challenge for New Zealand, and we see that rate of disproportionality in Maori played out in so many areas that we measure, including justice and youth justice. In a sense, those three things are the shadow that hang over the youth justice system. So I can't talk about challenges for the system without saying actually the biggest challenges for youth justice are these sorts of things. That said, there are 5 ingrained, I think, stark injustices in the current system for 14, 15, 16, 17-year-olds that we could do something about now that would make a difference. I wonder what yours would be, those here and those listening. What would be your 5? How would you address improving the current system, leaving aside the hugely challenging upstream issues that we face? Before I give you my 5, I just want to say this. In my view, our youth justice system works. It's misunderstood. I mean, a recent private members bill to bring in a demerit points system for youth offenders would have been a disaster. I'm sure misguided, but it would have reduced the system to a paint by numbers approach, which would have escalated young people into the adult court, which we know is one of the worst things we can do. Sounds good, but it almost guarantees further involvement in the system. See, what's misunderstood, never publicised, I hope the media are listening to this, offending rates have fallen dramatically over the last 10 years by up to 60% plus. I mean, that's great news. Offending rates have fallen. All the key stats in the youth justice system are in decline. You never hear about that in the media. But the stats give us no basis for some sort of moral panic that youth offending is out of control. On the statistics, it isn't. On the statistics, the graph is dropping everywhere. But it could work better. And that's really the point of my talk. Of all the issues in the criminal justice system, youth court included, this I think is the most pressing. How we address Maori disproportionality. And let's be clear, I'm not talking about all Maori, far from it, but I'm saying Maori are in the youth court at significantly disproportionate rates. One stat. Youth court appearance rates for Maori, are over 8 times higher than for European and other, as the stats classify it. Over 8 times higher. I mean, that ought to stop us in our tracks. Is that the New Zealand that we want? But there is some good news. The rates and numbers for Maori in the youth justice system are dropping, and they're dropping faster than for non-Maori. That's happened in the last 3 years. That's significant. Again, we don't hear that in the media. But the challenges are still enormous. You know, I went and visited in about 2018 the youth justice residence in Aotearoa. It's a national residence for all young people who it is said need to be kept securely. Of the 30 beds when I visited that were full, 29 were Maori. I mean, that's what our state detention system is becoming. Don't underestimate the challenge for the system. There are some encouragements. Ngāpuri Social Services in Kaikouri put in a bid for a much qualitatively different approach to dealing with young people who need 24/7 round-the-clock support. The proposal was for a much smaller 4-bedroom home. Interestingly, Ngāpuri said, we don't even like that. Why would we want a less bad version of bad? We can offer one-on-one support, and especially trained and supported homes with good mentors. 24/7, there'll be eyes support available. It's not something that initially Oranga Tamariki accepted, but in the end they did. A by Maori, for Maori approach demonstrated by Ngāpuri Social Services works. And the early signs are encouraging. And you know, I'm not talking about anything new when I talk about by Maori, for Maori approaches. This was always the vision of the 1989 legislation. Always the vision. I mean, look at this one provision for the lawyers who enjoy black letter, as it's called, law, one of the youth justice principles is that any measures for dealing with offending by children or young persons should be designed to strengthen family, whānau, hapu, iwi, and the family group of the child or young person concerned, and, think on this, to foster the ability of families, whānau, hapu, iwi, and family groups to develop their own means of dealing with offending by their children and young persons. And that Roman numeral 2, without saying it, is just about a prescription for by Maori, for Maori approaches. You know, the old legislation mentioned whānau, hapu, and iwi together 28 times. The vision was always a collective, community-based approach for our Indigenous Maori young people who came into the system. That's the vision way back from Puao Aotearoa and earlier. It's consistent, absolutely, with a Te Tiriti approach. And I say to some shame, because I was part of the system, we had a chance in 1989 for a revolution in the way we dealt with young people, particularly Maori young people. We blew it. There's no other way of saying it. The chance that we had, we missed, and we reverted back pretty quickly with some modifications for the same old, same. And it was our Maori judges who challenged us and helped set up rangatahi courts. I mean, that's Roman numeral 2 writ large. But we now have a chance, which isn't granted to many people, to have a second chance at a revolution with the new Oranga Tamariki legislation that, if anything, is stronger. In my view, the problem hasn't been with the wording of the Act when it comes to by Maori, for Maori approaches. It's been the practice for all of us. If even the legislation that we have was breathed life, if reports from social workers, if reports from the community and youth advocates actually took Roman numeral 2 seriously, they would be quite different. My own practice, as I look back and a judge, I can only speak for myself, would have been different. It was almost as if after the word families or whānau, I'd sort of subconsciously twinked out the words, whited out, pun intended. So that's a challenge for the whole system. What a vision it would be to have a standalone, fully contained youth court. There's precedent for it in Western Australia. At the moment, the least serious offences, infringement offences that a young person wants to challenge, the most serious offences, murder and manslaughter, get moved to the adult court, where the protections for young people paradoxically are less. Sentencing in some cases can be transferred to the adult court. My vision would be to have all offences for all under 18-year-olds held in the youth court, and we could do it. The vision in 89, the architecture, didn't quite go far enough. And part of that would be including all 17-year-olds in the system. It was terrific in 2017 when the government announced 17-year-olds would come into the youth justice system. There was real reservations about could the system cope, would it manage? So it was a two-step process. 9/10 of young people came in, but a small list of serious offences were reserved, still to be dealt with in the adult court. Well, as could have been predicted, it has worked really well. The system has not only coped, it's responded well to 17-year-olds. The time is on us now to complete that step 2, and get all 17-year-olds now in the youth justice system. In fact, that'd be the best news I could ever receive in leaving this job, to know that the government was going to take the small next step and complete that vision of all 17-year-olds included in the system. As to the minimum age of criminal responsibility, most people know it's 10 in New Zealand. On the face of it, that's an international standard. The good news is no one in New Zealand has ever been charged as a 10 or 11-year-old since at least 1974, as far as we can see, so it's a dead letter. We could get it to 12 tomorrow, this afternoon. I'd love it to go to 14. But the real question is, what do we do if the age of criminal liability is 14? What do we do with behaviour under 14? That if the age of criminal liability was 14 would be criminal, but it can't be called criminal because the age is 14. It's harmful behaviour. What do we do with that behaviour? The only solution we have at the moment is the care and protection system. And we would all have reservations about introducing more children into the care and protection system until we know that the work of radical transformation, most recently foreshadowed by the Ministerial Advisory Group, is complete. Then we could get to 14, because then we'd have an effective alternative to a child offender system. When I was a new District Court judge in Whanganui, I presided over an inquest, which District Court judges can do, of a 17 or 18-year-old boy who had tragically taken his own life in a Whanganui police cell one night at 3 a.m. in the morning, said to be a suicide-proof adult police cell, said to be of no risk to mental health. There is something about cellular confinement in the small hours of the morning that does great damage and puts young people at enormous risk. They act in ways that could never be predicted, and that inquest and the devastation that everybody involved with that young man went through has stayed with me all my life. If my son or daughter was in a police cell, I would be there every hour of every day that they were there. I'm so concerned. We play with fire when we remand young people into a police cell. This stopgap measure introduced in 1989 was only ever thought to be short term, but it's still there 30 years later. We must abolish it for the reasons I've set out in my paper. We have a policy in New Zealand in so many ways, not just our youth justice detention centres, which are 20, 30 or 40 bed concrete institutions. We have a policy of segregation, that is separating problematic behavioural children and young people from the mainstream and then aggregating them together. When you think about it, that grouping together is not a recipe for enduring rehabilitation. It just isn't. The risks of bullying, violence and trauma are sky-high greater. Its only justification, entirely flawed, is that it's cheaper to get all the challenging behaviour together. It's flawed because it doesn't work, and downstream the costs are greater. Through education, social welfare, the justice system. No one wins. We will always need some secure residents, but they could be much smaller. Look at Mahuru. Look at other options. They could be 1, 2, 3 bed homes scattered around the community. And they're really only remand centres now. They're not rehabilitation centres primarily. 80% of the young people in these youth justice residents are there waiting for their case to finish. And there are some, what I would call unacceptable police practices for children that need to be discontinued. And in the paper, I talk about a coherent police policy for dealing with young people. The United Nations have said children should never be strapped down in chairs, let alone in police cells by themselves. Spit hoods should not be used on children. And with COVID, we have other options now for the police. We understand their concern. They have face shields, PPE equipment. What might be called biometric information, including photographs for children, is a deeply confusing area of the law that needs very clear reform. I'm concerned at reports in some areas that police were asking close up to young people, want to take a photo. I wonder whether a young person would ever be capable of giving informed consent, which would include saying, you're not charged with anything, you're not in custody, you don't have to take a photograph, it's entirely your choice to walk away. We're only doing it because we think it might be good for police detection in the past and we'll keep a record of it, but it's your choice. I guarantee if every young person was asked that, they'd say, no way. At least they'd know what they were being asked. And I'm pleased that the police are taking seriously the concerns with police vehicle pursuit policy. I changed my mind, it's well known. As Principal Youth Court Judge, I used to believe young people shouldn't mock the law. They should be held to account. Crucial. I now think the risk to them and to innocent members of the community is too great. Unless there's a life-threatening issue, and most times, you know, it's minor offending that starts the chase, we can catch them tomorrow. Especially in the urban areas, there are increasingly good detection techniques with helicopters and cameras. The adult police officers need to use the brake, not the accelerator. Lives would be saved. So, to conclude, there are some legislative changes. We could develop the vision. We could get rid of some ingrained injustices with a world-leading, self-contained, standalone youth court. I don't know of a principled reason why we shouldn't. We could lift the age, the minimum age of criminal responsibility, MACR. We could have all 14 and all 14, 15, 16, 17-year-olds in the one court. And we must quickly abolish police cell remands. I'm told it's virtually defunct at the moment anyway, because we've got other good options. No better time to abolish that provision. And I've talked about those policy issues. Can I just conclude with a story? My very last day in the youth court was in Manukau Youth Court, and I was there to deal with a boy who was charged on the face of it with some quite moderate offending, car theft and dangerous driving. Actually, he'd been stealing cars and driving up the Papakura off-ramp to the motorway as an on-ramp and playing literal human dodgems at night with cars going the other way. He knew that he would be going to a youth justice detention centre. When I read about his background the night before, it could have been just about any one of the boys that I'd ever sentenced. And I've got some of the details here. I'll just read them out. Came from the background of a family with domestic violence. He'd been physically abused by his father. Substance abuse was endemic in the wider family. There were, not surprisingly, early behavioural issues. There was an unproven allegation he had made of serious sexual abuse against him by an adult wider family member, which had been to court. He said, I got the dates wrong. Talked about the May holidays, but it was the September holidays. But I know the man was acquitted, he said. I know it happened. I remember every detail of it. I'll never forget it. He had child, youth and family were involved in his life. He had 30 placements. Separated from his siblings when removed. Only now do we have a sibling unity provision in the Act. Disengaged from school. Parents had separated. His father was disengaged from his life. Substance abuse from the age of 11, very common start date. Attended 20 different schools. Out of school for 3 years, was at risk of self-harm, post-traumatic stress disorder issues. I mean, you couldn't read it without it drawing tears from stone. And it was all the upstream issues in his life that I talked about. And when it came to the sentencing, he said what no other young person ever said. He said, could we have a prayer? I said, sure, do you want me to say it? We'll stand. He said, no, I'd like to say it. The police sergeant, we can't say it in the dock, can you? Sounded reasonable. So the police sergeant went and got him and stood next to him, the only other person in the court supporting this boy. Positioned between the boy and the lord of the court, I noticed. And the boy played the most amazing prayer. I went from saying, I've done the time, I've done the crime, I need to do the time. And he said, I hope I get the help. I hope I get the help. And afterwards, I somewhat lamely shook him by the hand, came off the dock. The police sergeant hugged him, which was hitherto unknown from that police sergeant. And we saw the boy go up the stairs to the dock, down into the cells. I visited him about a month later as Children's Commissioner. He recognised me. They gestured together, and at the end he said, I still need the help. We've talked a lot about how we could reform matters outside the control of the youth court, but there are ingrained injustices in the youth court that would have, or the youth justice system, I'm talking about the court, the youth justice system, that would have helped that young boy. And my plea would be for him and all the others, these changes would enable him to get that help.
Thank you so much, Judge Becroft, for those remarks. So I'm going to take now just about 4 or 5 minutes to, I suppose, pick up on some of the challenges that you've laid out. So what I'm going to do is just give a very brief overview of some of the recommendations that is drawn from an ongoing piece of work between myself, Judge Becroft, Professor Ian Lammy, who is on the webinar somewhere, and Tamara Wilson-Tazi, one of our students here at Vic. And I think the context of this and that story that you've just shared with us, Judge, really illustrates that we need that long-term transformational change in our youth justice system. But we also think, and this was the pretty narrow context of this paper and this piece of work, that there are some immediate and medium-term fixes that we believe could reduce some of the harm that is occurring in our justice system. Because youth justice reform and justice reform more generally, as we know, is long and difficult. And there's always a tension between that desire for transformational change and also that desire to improve the daily lives of children and young people who are being held in our institutions and, in some cases, our adult prisons. And so an impetus for this piece of work for me was this idea that, and I include myself in as a person who's been working in youth justice, that we've ignored some of the small group of young people in our reforms that commit the very serious offences. So Judge Becroft has already pointed out some of these exclusions from the system. But the one that I've been most interested in are our children and young people who commit manslaughter and murder, because at the moment they're completely excluded. You know, and I've challenged our Children's Commissioner and other people that is a small but significant group of children and young people who have been largely ignored in critique of our youth justice system. So it's that unfinished nature of the youth justice jurisdiction and the age of criminal responsibility. So in this paper, which is ongoing, still got a bit of work to go, but I think we're getting there, so we should be able to release it at some stage soon. We've tried to work out some of the detail of what this might look like. And it's been a difficult process, and I've shared some of the paper with some close friends and colleagues, and some of them thought it was absolutely radical and could never work, and then others thought it was not radical enough. So we'll present a bit of it over the next few minutes. So in terms of the pillars of a principled approach, we think that Te Tiriti and the UN conventions that New Zealand has signed up to, or domestic human rights legislation, and the scientific evidence, particularly on children and adolescents' brain development, all support some of the proposals that we're going to put forward. So the first one, which Judge Becroft has already raised, is we call for the jurisdiction of the youth court to be universal. So the 1989 reforms excluded some of our children and young people. So we've got children and young people charged with homicide, some of our 17-year-olds, jury trials, joint charges with adults, and then on the lower end of the spectrum, some of our more minor offending. So those children and young people are currently excluded from our specialised youth court. They appear in an adult criminal court. Now, I do acknowledge that our judges and our professionals working in the system through case management and practice and procedure try and ameliorate and accommodate these young people, but it's still a completely unsuitable environment. So what we call for is, when it is necessary, and we strongly believe in diversion, for a child or young person to be charged, they should have the protections of the youth justice system. Automatic and permanent name suppression, which helps children and young people reintegrate, avoids some of the stigmatization, that we have the specialised procedure, processes and staff, and that the outcomes and principles are youth justice orientated. But of course, with that strong message that charges should only ever be really exceptional, and diversional and informal measures should guide the system. The second one, which Judge has already raised as well, removing that ability to remand to the police cells, and that story that you shared about that young man in Whanganui really illustrates that. It was always a stopgap measure. We are developing good alternatives, so why not, even though the numbers are small, just get rid of this completely. Raising the age of criminal responsibility. This is a very complex issue. And so, as Judge Becroft has mentioned, our age of criminal responsibility is 10. But as my students here in the room will know, it's a very complex system with a number of graduated steps in it. So what we call for, as we've heard, is we think that the age could be raised to 12 very, very easily. It could be done this afternoon, as you've alluded to, Judge. Because we know that 10, 11-year-olds haven't been charged for many years. They're already dealt with informally. As an interim step, we think that we could return to that position that happened before 2010, that we only charge 12 and 13-year-olds in very exceptional circumstances, and deal with these in the youth rather than the adults. And we believe that the goal, once developing work on the care and protection system has progressed, that age should be raised to 14. And that's the developing international norm for reasons of brain development and human rights. But we have been very cautious in saying that we think it should be incremental rather than going to 14 straight away, because we don't want children and young people to end up in a worse situation, given some of the situations in care and protection. So it would be really important not to develop an alternative that would mean that young people are deprived of, our children are deprived of their liberty or treated in a more punitive manner. Lastly, and I think for me, this is really the most important one. I think not many people realise that our Sentencing Act, when a child or young person is convicted of murder, and in some cases manslaughter, although life is pretty rare for manslaughter, they are treated like an adult. So we've got a presumption of a life sentence, so that's an indeterminate sentence. Your minimum non-parole period, the period before you can even go to apply for parole, starts at 10 years. So whether you're 13 or whether you're a fully fledged adult, the same law applies. And so since that law came in 2002, we've had numerous children and young people who've received that sentence. There's only been one child since 2002 who did get a lesser sentence, but those young people they are getting these life sentences. And I think this should be a priority for the government. It's completely contrary to international human rights law. It's harmful. It's disproportionate. It doesn't take account of the special status of children and young people, their right to a future, their right to be safe, and their right to be reintegrated and rehabilitated. So we believe that whatever a young person has done, we shouldn't draw distinctions between deserving and undeserving children. If you're under 18, you should have the benefit of the specialised youth justice system. So even, I was on Twitter this morning and I saw that MFAT had got something out about the death penalty. Well, in international human rights law, the life sentence for children and young people has that same status of being contrary to norms. So I think this is, again, something that could be done immediately. We have already ruled under 18s out from the 3 strikes. It would be very easy just to get rid of that immediately. So those are some of the calls that we'll be making in this paper, which I hope we'll be able to get out soon once we've done the last bits of work. So that leaves us about 10 minutes for questions, I think. So I'll invite Judge Becroft back up here. I'm going to stop sharing the screen so we can take questions from people in the room. So we might start with a question, if there's a question from people in the room, and I will catch up on any questions that there are here from the people who are joining us virtually.
No contempt of court. You can challenge, dispute or argue, and you're invited to do so if you wish.
Judge Becroft, thank you for your talk. My question would be, given that one of the biggest problems that ran through things that you outlined today was what people do in practice, how do we actively improve people in practice?
So the question was, given one of the recurring themes was deficiencies in practice, what do we do to improve practice? Well, I mean, we had a very comprehensive report from the Ministerial Advisory Group regarding what we needed to do to improve social work practice, which was better induction, better supervision, better training, lower case numbers, better oversight, giving life to the by-Maori, for-Maori legislative approaches. I mean, I'm optimistic. That's a very short-term solution because I think most of the services would be better delivered by Maori in the community rather than the government. And we have a insatiable desire in New Zealand to think if we train up government staff, they'll do it better. Now, that needs to happen and they will do it better, but the wider vision's got to be shifting a lot of the work from the government to the community. And I think that would be we know what some of the practice issues are. There are programs and frameworks that have just got to be followed. And short term, there'd be an improvement. But long term, it's moving much of that work out of the government into the community, properly resourced, devolved. That's part of the revolution.
Okay, so I'm going to put to you some of the questions that have come through virtually. So somebody has asked, aside from the lack of resources in the welfare system, which you have mentioned, what would be the main obstacles in attempting to raise the age of criminal responsibility to the UNCRC committee standard of 14?
For me, my heart says there's no obstacle. We should just do it. I mean, there'd be important public discussion and reassurance to take place. My head says, I don't want under 14-year-olds to be put in a system an alternative system that could compromise their rights with no necessary end point and where they could end up being worse off than the situation now, which is quite nuanced. So the practical challenge that goes hand in hand with getting to 14 is to say, is what we would put in place as an alternative genuinely child-focused, child rights-based, and it does do the job both of protecting the rights of the young person, protecting the rights and interests of the victim and the community, because that's part of any system, and it does no harm. Because don't forget, prior to 89, we had a welfareised system and we had what we called the Mars Bars boys with minor offending who'd be 4 years, 3 years in a youth justice boys' home, out of all proportion to the offending. So we need to be very sure that we've got a fit-for-purpose alternative. That's the only drawback for me. And I know someone like Matt Tukaki is listening to this. That's the challenge for the Ministerial Advisory Group with care and protection within Aotearoa Tamariki, a fit-for-purpose devolved system that's going to work for under 14-year-olds.
Okay, so somebody's asking about the call for addressing the chronic institutional racism towards rangatahi Maori in the justice system.
Well, I say, where is the call? I had thought when I talked about the real underlying causes, I mentioned the words the enduring legacy of colonisation and modern day systemic racism. I mean, I need to call it out. I remember at a big conference talking as a new commissioner about systemic bias and discrimination, and a queer stood up and said, "You're a good guy, Commissioner, but you've talked about what you've done personally when you've been upright, breathing and alert. I always thought unconscious was when you're horizontal and flat. Why don't you man up and call what you were involved in racism?" That's what children call it, I might say. I was brought up to call it unconscious bias and discrimination. So I think in what I said, I made very clear that the lethal cocktail of the legacy of the colonising process and modern day racism together cause great harm for too many rangatahi Māori. Let us be clear about that.
Okay, so we've got quite a lot of questions coming through, so I'm just trying to get different topics. So someone asking, with regard to abolishing the 4 large-scale YJ residences, where do you believe young people charged with the most serious offences, murder, manslaughter, etc., should be held?
I think we could easily have therapeutic, expert, staffed, smaller scale, community-based residences that were secure, but provided genuine one-on-one long-term rehabilitation. That had been my vision. That would keep the interests of the victim, the community, and most importantly, the child, who is after all a work in progress and capable of great transformation, will keep all those things together. But the locking up in a largely concrete institution together just has in it the seeds of futility and lack of vision for our country as a whole. And we're not solving problems, we're simply parking them for some time. And we need to do so much better. And we could do.
We might take a live question.
I wonder how important you think that your recommendation that the independent children's monitor externally monitors the running for the years, and why that was.
Well, that's a very provocative question, which is the independent children's monitor, why isn't empowered to be genuinely an independent monitor and call out Aotearoa Tamariki, and why didn't, in fact, that monitoring entity end up being housed in the Children's Commissioner's office? Yeah, that is a, I think, deep and significant question that in the end was a government decision. The thinking goes something like the monitor will be something like a scientist who collects the data of compliance or non-compliance and presents it to the government and to the minister to do something about it. And a strengthened Children's Commission, because that's what we're becoming, properly resourced, will be the advocate for change. I, however, wish the independent children's monitor, I've been public, was separate from government, not a department of government or an entity of government with an appointed chief executive. I think it'd be better for the independent to be genuine independent, and I'd love the ICN to have the power to make recommendations. But I doubt that the Children's Commissioner that follows me or the Children's Commission will fail to see that advocacy for change is a role for the Children's Commission. And I hope that that's made explicit in the legislation, because someone's got to have the role. And let me say, it is not pleasant. It is not easy. It's been the toughest part of my job, saying to the government that the system, particularly for tamariki Maori, isn't working and is doing harm. And that's a tough message for the government. But that's what an independent watchdog has to say. I mean, no one finds it easy to receive or to give, but that needs to be wired into the system. And yes, I'm concerned that it's not sufficiently wired into the system now, wherever the independent children's monitor is placed.
So we're drawing to the end of our time, but I've just seen, I know there's a lot of excellent questions coming through, but I thought this one would be quite a good one. So, which is probably an area we haven't addressed. So someone saying they're very concerned for victims of sexual violence dealt with in YJ and the FGC, and making the point that any transformation needs to also include the rights and interests of victims.
Yeah, and I couldn't agree more. And it would be a deficient system which didn't do that. I mean, the evidence is, and there are experts in the field, but the overwhelming majority of victims of sexual offending from the youth court are stepbrothers, stepsisters, next door neighbours, or young people themselves. So it's absolutely crucial that there is very good help, support and intervention for victims, and long-term help for children and young boys, as is mainly the case, who offend. Both those things are possible. But again, one solution of aggregating those boys together, as we do with the Harmful Sexual Behaviours Unit in Christchurch, which is a good attempt, actually is the wrong thing to do. And we could provide that long-term assistance, and all the evidence says they can be helped to put that behaviour developmentally behind them, can be done better in the community one-on-one.
So our time draws to a close. Would you like to offer any final remark before we finish?
I end where I started. Commissioners come and go. Commissions come and go. But the work of prioritising children, the 23% in our country, endures and remains. And let us recommit and redouble our efforts to doing that, because in the words of Dame Fina Cooper, it is nation building. It isn't optional, and it is foundational for all of us and for the whole country. Tēnā koutou.
So I'll close things off, as I know both our virtual and in-person people will have places that they need to be, but I know there were many more questions online than we can get to, but I think you might be releasing some of your speech notes from today.
Yes,
possibly, and
all 5 bit by bit will be released. They don't purport to be the answers. They purport to be one person's reflection over 5 years' experience to prompt discussion and thought. But actually, they are the answers for abolishing police remand, including all 17-year-olds.
Don't sell yourself short. So anyone who wants further information will be able to look at that. And I think the recording of this will be available too. And hopefully the other paper will be out as well. So thank you so much for joining us. And I'm going to say farewell to the webinar people and switch them off. Lovely to have you with us. And thank you again.